And tonight I'm joined by John Malcolm. He served as Deputy Assistant AG in the DOJ's Criminal Division and is currently the Vice President for the Institute for Constitutional Government at the Heritage Foundation. Thanks very much for coming on the program. Appreciate it. Tell me why you think I'm wrong.
Well, you began by saying that she was leading an effort to overturn the election. I just think it's a mischaracterization of the facts. She believed, as did millions of other people, that the election was stolen. She might have been right or wrong about that. I'm not contesting that. She certainly sent text messages to people who were involved saying, fight on, you should fight. And she was at the ellipse along with hundreds of thousands of people. As you noted, she didn't go to the Capitol. You read a part of that code of ethics that all the justices signed on to, but there are two parts you didn't read. One is that under the Supreme Court, they go by the rule of necessity, which is that it has to be crystal clear that one of the justices has to recuse because they can't be replaced, unlike a lower court judge. And with respect to spouse's involvement, it says that a justice shall recuse if a spouse is a party to the proceeding. No. She's not. A lawyer in the proceeding. She's not. Right. Has an interest that could substantially be affected by the outcome. She has no more interest in the outcome of this case than any other Trump supporter who believes
really?
That
let me read you
screwed.
this.
Yes,
this is
hold on 1 minute.
Hang on.
And also that she has to be a material witness.
But that's not relevant. The material witness isn't relevant.
Right.
The only one that's relevant
is the substantial outcome.
The only one that's relevant is number 3. That's the one I read, and that's the debate. Here's what Ginni Thomas, in her testimony with the January 6th committee, said. Number 7. I was involved in trying to identify fraud in a timely manner by certain states that I had heard through friends or whatnot or in the media, so I certainly was involved in things that were trying to get to the truth. Yes, she is the wife of a Supreme Court justice who is actively lobbying people in various states. She's not just writing op-eds. She's not just saying publicly, look, I think this was a problem. She's behind the scenes using her name and her position to try to get them to act. That seems to me beyond just not having an interest.
One, she doesn't have a substantial interest in the outcome of the case any more than any other party activist. 2, this case is not about whether or the election was stolen or not. It is a pure legal question about the scope of Section 3 of the 14th Amendment. 3, she was so not involved and such a non-player in this. She was interviewed for 4 hours by the January 6th Commission. They issued an 845-page report. Ginni Thomas is mentioned 0 times in that entire report. She was a side note. She was no more actively involved than any other party activist. And she is certainly a party activist. She does not give up her rights under the First Amendment to associate with people.
No one's talking about giving up her rights. I'm just saying that you know this, that judges, federal judges, and you would think that that obligation should apply to Supreme Court justices, bend over backwards to avoid even the perception of impropriety and bias. And this one, if you're going to say that's the standard, right? Let's even put aside what the technical definition is. I can tell you, I know so many federal judges at different levels who have recused themselves from cases they wanted to remain involved in because they were just concerned about perception, not because there was any actual conflict. Isn't that at least the case here?
Well, first of all, the rules change a little bit for Supreme Court justices because unlike lower court judges, they cannot be replaced. And here, the definitions matter. She does not have a substantial interest in the outcome of this case more than any other Trump supporter who was involved in looking into the facts of this case. Legal ethicist Stephen Gillers at NYU, in cases that were far closer than this, has said, quote, we are long past the day when a wife's opinions are assumed to be the same.
That's true. That's for sure. But let me, John, let me just switch gears real quick with you.
Sure, of course.
What do you think that the court's reasoning? I'm convinced the court is going to allow Donald Trump to stay on the ballot. What's your prediction as to what legal theory they will go with on that?
I think it'll be one of 2. The neatest and cleanest things is either to say that he is not an officer of the United States, as that phrase is used in Section 3 of the 14th Amendment. And the other is that that provision is not self-executing and requires an act of Congress, and there is no implementing statute from Congress.
All right, we shall see. John Malcolm, good to see you. Thanks for coming back on. Appreciate it.
Good to be with you.
Thank you for watching. Go to newsnationnow.com to find NewsNation on your cable provider. And don't forget to click the red subscribe button below to get more of NewsNation's fact-driven, unbiased coverage.